SJC 12244, Commonwealth versus Amaral.
Ms. Baranoff, good morning.
May it please the court, I'm Susan Baranoff. I represent Jeremy Aramarol, who was convicted of murder in the first degree of Tiffany Durfee in New Bedford. Now, the Commonwealth's theory was that Mr. Amaral alone killed Ms. Durfee, who was his friend and fellow drug user, by cutting her throat and stealing a TV and then selling it for drugs to a drug dealer named Jason McCarthy. There was, however, evidence at trial and in connection with the motion for new trial that someone else could have been present and responsible for the killing, either Michael Garcia, who was described as Mr. Amaral's brother, they were raised together, and who was a fellow drug addict, or Darren Andrade, also known as D-Lock, who was another drug dealer in this case. Now, I'm going to try to touch briefly on the first four issues raised in my brief, depending on the court's questions, leaving the more general 33E review to my brief. Now, the first issue concerns whether Mr. Amaral's first two statements at the police station should have been suppressed on Miranda or voluntariness grounds. And I'm not going to belabor this point. The relevant legal standard and the standard of review that was discussed in the Tremblay case is well known. But I will say that I believe that the court needs to itself scrutinize the videotapes because to the extent...
Were there witnesses at trial that testified as well?
I'm sorry?
Were there witnesses at trial who testified as well as the videos?
Well, when we're thinking in terms of the motion to suppress, we're looking at the videos that were introduced, and then the videos were also introduced at trial.
No, I don't mean trial. I mean a motion to suppress. Were there other witnesses besides the videos themselves?
I'm sorry, I couldn't hear you.
There are other witnesses. Was there witness testimony in addition to video testimony? The video.
There was witness testimony
You
at
have
the
to credit
motion.
the judge's findings as to the witness testimony.
The judge found credible the testimony of two police officers.
Those are the only two who testified.
Yeah. Trooper Perez and Detective Alumba. And I would suggest that their testimony adds very little to the videotapes. Trooper Perez did say he didn't think that Mr. Amaral appeared to be intoxicated without reference to whether he meant alcohol or drugs. But we are seeing on the videotape Mr. Amaral just the way Trooper Perez did. And Detective Alumba's testimony concerned a case many years in the past where he interviewed Mr. Amaral, and it seemed to revolve more around his sophistication with the court system and understanding of Miranda warnings, but it doesn't really tell us that much, I would suggest, about whether Mr. Amaral was in custody for Miranda purposes in this case, or whether in this particular situation his statements were involuntary. And also, the motion judge in her decision strayed somewhat from the focus for purposes of Miranda as to whether the objective circumstances would lead a reasonable person in Mr. Amaral's situation to believe he was in custody. So I think the court needs to take a fresh look at both the Miranda and the voluntariness issue. And in doing so with respect to the Miranda issue and looking at the four factors articulated in the Groom case and so often discussed, I think the first factor where the questioning took place, because it was questioning in a secure part of the police station and in the first instance in a windowless room, weighs in favor of a finding of custody. And although the Commonwealth suggests that Mr. Amaral voluntarily came to the station, this was only after the police were kind of hunting him and going to his mother's house, and he knew that he had a probation revocation hearing hanging over his head as well.
But he was,
the evidence on
he was
this,
trying to get help. He was hoping that whatever he said would help him at the probation violation hearing.
yeah, he did think that perhaps that could be helpful, but nevertheless, in terms of getting him to the station, there was an aspect that wasn't so voluntary about it, perhaps.
It seems like the first, I still call him Brian factor.
I'm sorry,
I still call him Brian factor, but as to the first groom factor, seems like that's just neutral.
The first?
Groom factor seems, the location, seems like that's just that doesn't cut either way, it seems, on the custody issue.
Well, I think if he's being interviewed in a secure part of a police station, it does cut in favor of a finding of custody. It's certainly not dispositive, but it is one factor. The second factor, I think, is perhaps closer, whether the officers conveyed any impression that Mr. Amaral was a suspect. I'd suggest that the evidence is a little more murky than you would think by reading the motion judge's opinion, and that it was only kind of late in the first interview that anyone unequivocally said, "You're not a suspect." And up to that point, what was said was more equivocal, and some of what was done, searching the phone, patting Amaral down, suggesting he wasn't telling the full truth, was more suggestive of the fact that he was a suspect earlier on. I will say that the third factor, the nature of the interrogation, probably weighs more in favor of the Commonwealth and against a finding of coercion or custody, in the sense that the police were not, from the get-go, aggressively questioning Mr. Amaral, and Mr. Amaral did participate and guide the discussions to some extent. But you also have to consider that the first part was a 3-hour interrogation, and there was that point at which he was confronted with, "You're not telling us the full truth."
Can I just ask you, can I ask you, what did the witnesses testify to as to his extensive criminal history? What was the nature of his criminal history?
He had robbed banks. And that was the testimony given by Detective Alumba when he had interviewed him several years ago about a bank robbery.
Had he been incarcerated?
Not all that recently. In the recent period before this arrest, he had been out. He'd been struggling with drug addiction, but he had been out, and I think he remarks to officers at one point, "This is the longest I've been out of trouble." So he had a criminal history, but it wasn't right up to this particular moment, but he did have this probation hearing hanging over him.
For what?
The fourth issue, as you know,
For what was the probation violation?
It's not clear from the record what that was about.
Okay.
There's
right.
some suggestion in the interviews that it may have had to do with some conflict with his wife or his girlfriend, but it's not clear. On the critical issue, although not dispositive issue of whether Mr. Amaral was free to leave, the evidence was that he remained in this restricted area of the police station except when he was escorted to have a cigarette or to go to the bathroom, and when he left to do a supervised drug buy with DLOC, which culminated in his arrest, the arrest of all of the people concerned, and they were brought back to the station. I think if you look at the evidence closely, he wasn't told that he wasn't in custody and was free to leave, except for some brief statement at one point, "There's nothing to hold you," and then there was a sort of a garbled portion after that. So I'd suggest that when you do your independent review of these 4 factors in the videotapes, there was a Miranda violation here, because it's undisputed that Mr. Amaral was not given his Miranda rights until something like 9
Until he
hours after.
became a suspect.
Yeah, and at that point, nothing was
Nothing
admitted after
changed.
that.
Right.
Right.
And that was after that person said that he had delivered the bloody TV.
Yes, that was when the police had additional information, confronted him with it, and he elected to, he was given his Miranda rights, and he elected to not go further. On voluntariness, I think that the motion judge did correctly focus on whether Mr. Mr. Amaral was drug impaired, but she perhaps didn't weigh all of the evidence on the subject. He made direct statements at the station that he was on heroin and cocaine. He probably shouldn't say anything because he was a fucking mess, although he added, "But I want to help you." He was afraid he was going to get dope sick, and the reason he was scratching himself, which led to one of the officers patting him down, was it was a symptom of his drug usage, his addiction. So all of those things need to be considered, and I think when you look at the videotapes, you'll see a very jumpy person and someone who, you know, seems somewhat high and maybe a little euphoric, that are symptoms that are associated with heroin usage. I will note that the Commonwealth does not argue that if these statements were admitted in violation of Miranda, or although they were involuntary, that there would be any harmlessness or harmless error, and I don't think the court could find, because of the importance of the statements, that any error would be harmless beyond a reasonable doubt. Let me turn to the second issue, which was the exclusion of testimony about a statement by a third party during a conversation between Mr. Amaral and his mother on the phone. The mother is asking, and this is brought out by the prosecutor, the mother is asked, what did Jeremy say when he called you on the evening of March 12th? And she said he had a TV that someone was trying to sell, and he wanted to know if I wanted to buy it. And then on cross-examination, defense counsel brought out that he said, I have a nice TV, it's plasma TV. And she had responded, to the prosecutor's question, I told you many times, don't call me trying to sell me things. And then she elaborates and says, Jeremy, I told you not to call me about buying anything, especially it's stolen. And that was the context in which defense counsel wanted to bring out the statement by what he represented based on a police report, he said, and a grand jury testimony, that the mother heard a woman in the background say, it's not stolen, it's my TV.
Are you aware of any case that in Massachusetts or anywhere else that's ever under the doctrine of completeness said, in order to understand completely and not give a misleading impression to the jury of the nature of the statement, that you have to hear some third party's comment?
I wish I could say that I'd found a case involving a third-party statement, but I think that analyzing the requirements of the rule of completeness, this would fit. The conversation or the remark by the third party is on the same subject that's being discussed. It's, I think, part of the same conversation about whether she's interested in the TV, whether it's stolen, and I would suggest that the statement is necessary to an understanding of the conversation, because the jury otherwise is left with the impression that the mother is saying, I don't want a hot TV, and her son is not saying anything. And in essence, his silence is explained by this comment by this third person who says, it's not stolen, it's my TV, and it makes it unnecessary for him to respond further. So even though I couldn't find a case exactly on point.
I didn't go back to the record in this case. I'd spent a lot of time in the last case doing it. But I gather that the judge allowed her to testify as to whether the voice was female or male. And when she actually testified, she said that was a male voice.
That's true. And
So what do we do with that?
It's a bit mysterious. As I said, defense counsel represented quite clearly that he had a police report and grand jury testimony in which she says it was a woman. And unfortunately, those items are not part of the record. But at trial, the Commonwealth did not contest that representation that it was a woman. I think it is possible, looking at the conversation and the actual question that she was asked, which was, then, did you hear anyone else in the background? It's possible she may have misunderstood and may have heard yet another person who was male in the background, but that's as much light as I can bring on that subject.
Okay, but what do
At
we do with
present.
it now? I mean, we've got a record in which she indicated that the person who she was referring to was male, and if it's male, it doesn't help you very much because it would not be the victim. So what do we do with it? I mean, do we basically say we accept that even though she said it was a male voice, what she
Well, I
meant
think,
and
number one, she may have been confused or may have been thinking of another person in the background. And number two, we're left with a situation where there's no reason to doubt the representation about the foundation for the question, and defense counsel couldn't go any further. I mean, if allowed to go further, he could have used a report or a grand jury testimony to either refresh her recollection and clarify the situation or impeach her, I suppose. But I think the former would be the more likely.
But don't we have to evaluate prejudice as if it was indeed a male voice that she heard? 'Cause that's
Well, I
what-
don't think you can
That's what
assume-
our record will reflect. The question is a female voice, I guess, or the proffer is a female voice, but the testimony is that it was a male voice. So don't we have to essentially say, okay, if we're evaluating, assuming you're right, we're evaluating prejudice, and then it was, what benefit would it be if a male voice say it's not stolen?
I think you have to look at the record from the point of view is that it is not clear it was a male voice she was talking about because of the representation of counsel. And I might say that I think that the prejudice in this case, in the case of this ruling, is most apparent because there is a charge of felony murder, but this notion of whether the TV was stolen or whether Ms. Durfee had agreed to sell it for more drugs was quite central, and it really has a bearing on, whether this is deliberate premeditation or even an intentional killing. So
The issue's not the relevance of the statement of this other person. The issue is whether or not this other person's comment about the TV is necessary so that there's not a misunderstanding by the jury about the conversation. But what we're doing is, what you're arguing is that you are extending the doctrine of completeness to not a particular statement, but to somebody else's statement to clarify the statement. I don't think we've ever done that before.
well, I think it's a natural extension or a natural application in the sense that it's part of the same conversation. It's on the same subject, and we would say it's necessary to explain and dispel a mistaken impression that if Amaral's mother is accusing him of trying to sell her a hot TV, he's not saying anything. This would make it understandable why he may not respond. Let me go on to, unless there's a further question, go on to the next argument, which is the failure to charge on voluntariness of Mr. Amaral's statements under the humane
That
practice.
your time is limited, so pick your best one, because you've only got a minute left.
Well, I'd just say that I think that both of those failure to charge issues on voluntariness and joint venture are meritorious in the sense that the voluntariness, there was only more information at trial about drug use, with Amaral testifying I was jammed out of my mind and Garcia confirming that they did heroin before they went to the station. And on the joint venture situation, the judge on the one hand felt that there was enough in the evidence to warrant a charge that mere presence wasn't enough, but did not give the full joint venture
But I don't
instruction.
get that. Why would it help the defendant to have an alternative theory in which he could be found guilty?
Well, there isn't any evidence that this was a tactical judgment, and I think in this case where you had evidence that Mr. Amaral was present, he disposed of the TV, he had a close relationship with Mr. Garcia, and he said this whole thing happened very fast, it would have been important for the jury to be told not just that you need knowing participation and an intent to commit the crime, but also mere association between two people and the failure to prevent a crime would not be enough.
If they give joint venture when the defendant doesn't ask for it, and the jury finds him guilty, aren't we going to hear from you that the judge made a joint venture instruction which was not asked for by the defense counsel, and he may have been found guilty on a joint venture theory, and there's no evidence or inadequate evidence of joint venture, and therefore he gets a new trial?
I think you take the case as it unfolds, and here there was evidence, although the Commonwealth didn't rely on that theory, there was evidence, including from the defendant's statements, from which there could have been a finding of joint venture, and in that situation, the full charge should have been given. I think this Lanskus case, 433 Mass 678, which is cited by the Commonwealth for a different purpose, is a good indication that the whole evidence has to be considered, and then a decision made about whether to charge on joint venture.
Okay, finally, as to the motion for new trial, if we can get right to the heart of it. The defendant testifies and said Garcia did it. He said that if he had known that he could have had the child's, if he had known about the child's remark, he would have claimed that it was Mr. Andrade, D-Lock, who did it. But what do we do with the fact that when he when he testified, he didn't say D-Lock did it. He said Garcia did it. I mean, how do you get a new trial, especially when we have a Judge Nickerson who says it would have been week T to have made that argument, that his best argument was the Garcia did it argument?
Well, I think you can only defer to what the motion judge found up to a point, because he was the trial judge, so he had the opportunity to assess the evidence that came in. On the other hand, this finding of weak T or lack of prejudice or not probably going to be a real factor in the jury's mind is in the nature of an ultimate finding or a conclusion of law, and it's based in part on looking at the videotape of the interview of the two young men, and this court is in just as good a position as the trial judge to assess that videotape. So I think that there has
Not in the same position as the trial judge to evaluate the weight of the evidence at trial.
certainly in terms of his assessment of how significant the evidence was at trial, deference is due there. But if you're comparing that to the video of the child, you're in the best position to assess that video, is all I'm saying. And there's a constitutional overlay here in terms of the decision, which allows you to give review. And I'll also say that the judge's decision is tainted somewhat by his notion that it was trial strategy. But our whole point is that there was a failure to provide exculpatory evidence, and if that evidence had been provided, that would have affected trial strategy, and particularly the defendant's decision as to whether to testify. That is his decision, not counsel's decision. And so that's the nub of it. And also this notion that somehow this is all irrelevant because his testimony at the first trial would come in at a second trial, we suggest is also flawed, because the Harrison-Charos exception should apply in a situation where, if the Commonwealth failed to present exculpatory evidence and the defendant didn't testified in reliance or because of that, then that testimony should not be admissible at a retrial.
All right, thank you.
Thank you.
Ms. Sylvia.
Good Good morning, Your Honors, and may it please the Court. Erica Sylvia on behalf of the Commonwealth. The first issue I would like to address in this case is the defendant's motions to suppress his statements to the police, and those motions were properly denied. Nope. Those motions were properly denied for two reasons. First, the defendant failed to meet his burden of showing that he was in custody up until he was, in fact, Mirandized at the beginning of the third interview. Second, the Commonwealth did meet its burden of proving beyond a reasonable doubt that the statements were made voluntarily. First, with respect to Miranda and why that wasn't warranted, the test is whether a reasonable person in the defendant's circumstances would have perceived the environment as coercive. Here, Judge Dupuy, she applied the correct test, she applied the correct Bryant or Groom factors, and she made very specific findings based not only on the video, but on the testimony she heard at the motion hearing. First, with respect to the place of the interrogation, yes, this happened at a police station, but the defendant arrived there at his own volition. Had he have answered the door to the officers who came to his apartment, perhaps the interview could have been there at a place of his choosing. This court has recognized in Commonwealth v. Molina that a location of the police station does not de facto turn an interrogation into a custodial one. It's also held that any intimidation caused by the location can be mitigated by the nature of that interrogation, the informality, the friendliness, the politeness, and that's what we have here. Both Perez and Westgate remained informal throughout the whole time. They let the defendant lead at many points. In fact, the first one to speak in the interview was the defendant. He arrives, I want to help, here's my phone, look at my phone, you can search whatever you want. At one point he says, you can even strip search me, I'm clean. The officers remain friendly and non-confrontational. At one point they do suggest that he isn't telling the complete truth, but that again does not turn an interrogation into a custodial one on its own. Moving on to whether they convey a belief or opinion that he's a suspect, I would argue that it's very explicit that he's not a suspect, and that's made very clear to him in their statements to him. They tell him, quote, we don't care about your record, we're not looking at you. When he asks, am I a suspect? They say, you came here to talk to us, you're somewhat of a witness, there's nothing to hold you for, you're not a suspect, if you were, you would know. So I believe a reasonable person in the defendant's circumstances would understand the words you're not a suspect to mean you're not a suspect. With respect to the escort he's provided to use the restroom and to the patio for a cigarette break, this court's recognized in Commonwealth v. Hilton that an escort to use the restroom in a secure location, not generally open to the public, does not again turn an interview into a custodial interrogation. And a reasonable person in those circumstances would understand that it's given the nature of the building itself, that it's a secure facility, and this individual is being led through the employee's private locker room, that's just not something that's open to a general person walking in. So the totality of those factors, given those factors, the defendant failed to meet his burden of showing that he was in custody and therefore Miranda warnings were not warranted. Pivoting now to voluntariness, it was the Commonwealth's burden to show that the statements were made voluntarily, and that was proven not just through the video, but by the witnesses who were called at the suppression hearing. It was our burden to show certain factors that weighed in favor of voluntariness. Officer Alumba testified to the defendant's prior wealth of experience with the criminal justice system and that he would have understood that he had the right not to speak, which in fact the defendant made clear in his interview, and he noted that he knew he didn't have to talk to officers, but he continued to say that he wanted to help them. And further looking at the tape itself, yes, there was evidence that the defendant ingested drugs at some point before arriving. That's clear. And Judge Dupuy notes that and uses special care. And she goes through a long analysis and she analyzes the tape to see whether or not there's any signs of impairment, any signs that would have been known to the officers, and any signs that are clear through the statements he makes. And she finds no signs of impairment. She states he was cordial, alert, he answered rationally and responsively to all the questions that were pointed of him. He offered detailed information. He was never physically restrained. And at several points, he attempted to benefit himself. So he definitely had self-motivation in arriving at the station voluntarily and trying to help. He was trying to get some leverage for a favorable outcome at his probation surrender hearing. So given the totality of the circumstances, I would argue that the motions to suppress were properly denied. Moving on to the second issue, the hearsay issue, with respect to what Mrs. Amaral allegedly would have testified to if she was allowed to continue. Judge Nickerson got it right. This was classic hearsay. It was an out-of-court statement offered only for its truth. It was only, defense counsel at sidebar only posited that it would have been admissible under the doctrine of completeness. He never offered a non-hearsay.
But as you recognize, I think in a footnote in your brief, to have something come in under the doctrine of completeness, the evidence could otherwise be hearsay or
Sure.
violate some other law of evidence, and if the case were otherwise, you wouldn't need a doctrine of completeness.
Sure, sure. So yes, the fact that it was hearsay doesn't in and of itself mean that it could not be admissible under the doctrine of completeness. I do recognize that. However, the doctrine of completeness wouldn't apply here on the whole. First, the doctrine requires that there's an adverse party trying to admit the portion of evidence that would provide the previous portion with some context, and we don't have an adverse party here. Both parts of the statement are coming out on cross-examination. We have Mrs. Amaral saying, Jeremy, don't call me to sell anything, especially if it's stolen, and then again on cross, they're trying to get in this statement of it's not stolen, it's my TV. So the doctrine of completeness is simply not applicable here. The only case I could find that touches on a third party's statement trying to come in is Commonwealth versus Mandeville, and it's cited in the Commonwealth's brief. And it's similar factually, where a witness hears a third party over the phone making some statements, and that witness is trying to testify to those third party statements. And again, it's ruled inadmissible by the judge on hearsay grounds. So again, I would just argue that the judge properly sustained the Commonwealth's objection.
And it's the defendant, you're saying, who's trying to put in the evidence of the conversation?
Yes, at least my recollection is that's what happened.
About the conversation with the mother?
In this case, you mean? Yes, both parts are coming in, are being elicited by the defendant.
And so what about the statement actually would have made it hearsay? I know it's an elementary kind of question. but
Sure.
I
Well,
always like it.
first, it's just an out-of-court statement by a third party. We don't know who they are, and frankly, it might not even matter who they are. But it's being offered only for its truth, that it's not a stolen television.
Or is it being offered for her belief? Well, never mind, okay.
Well, I guess my position would be that her belief is that she just doesn't want to buy any items he's trying to sell, stolen or not. She makes that clear, stop calling me to try to sell anything, especially if it's stolen. So the notion would be that she just doesn't want to buy anything from him. If there are no other questions with respect to hearsay, I'd move on to the third issue of the jury instructions, or the omitted jury instructions. First, with respect to the humane practice instruction, it's a Commonwealth's.
Requested, by the way.
What was that?
Was
I'm
that
sorry.
requested?
The humane practice instruction was originally in the defendant's model instructions that were given over to the judge, but the defense counsel conceded at several points that the voluntariness would not be a live issue at trial. And at the charge conference, he agreed to strike that instruction. Judge Nickerson asked pointedly that it can remain, that he can give the instruction, and they agreed that it was not warranted given the evidence in the case. Yes, there was some evidence of drug use that was raised, and while drug use does bear on the question of voluntariness, this court's held in Commonwealth versus Neves that while there was evidence of a defendant's drug dependency and possible drug withdrawal, voluntariness still needs to be raised with sufficient point to warrant a humane practice instruction, especially done so on the court's own motion. With respect to joint venture, I would just briefly say that to give the joint venture instruction would to impose on the Commonwealth a burden that the Commonwealth did not set out to ever meet. The instruction charges the jury with the element saying the Commonwealth must prove, the Commonwealth must prove, and the Commonwealth here never offered any evidence inferring a joint venture took place. It was the Commonwealth's position that Jeremy Amaral was the only person in that home besides Ms. Durfee and her children.
And defense counsel did not ask for a joint venture instruction.
He did not, no. And I feel that even though he got the mere knowledge and mere presence is not enough, that went to his benefit if the jury credited the defendant's own testimony placing him at the scene. And in the defendant's brief, there's this notion that the jury wouldn't know what to do if they came to reasonable doubt, what would be enough to convict. And it's the Commonwealth's position that they were very clearly instructed that if any one member of the jury had a reasonable doubt, acquittal was warranted. So it's our position that neither one of those instructions should have been given, and the judge properly omitted them. In doing so, giving those instructions would have confused and muddled the issues.
Motion for new trial.
What was this?
Motion for new trial.
Yes, the motion for a new trial issue. It's our position that Judge Nickerson, who was the trial judge, he properly denied the motion for a new trial summarily, and he denied an evidentiary hearing. He made very specific findings in his decision, and he stated clearly that no substantial issue was raised on the papers warranting an evidentiary hearing. First, with respect to either the newly discovered evidence or the undisclosed evidence, however you want to draw or characterize that evidence, either way it would boil down to a real factor test, whether the jury would have perceived that evidence as a real factor in their determinations. And it's the Commonwealth's position that Judge Nickerson got it right. It was weak tea. That if you watch the video of the child, he goes back and forth. He states for the first half of his interview, no, I didn't see anyone, I didn't see anyone. But when I woke up, the TV was missing, and the man who took the TV must have killed his mother, is what he concludes. And they say, well, how do you know? And he says, well, because when I woke up, it wasn't there. So all of his conclusions are drawn from the fact that when he woke up, he didn't see his television. He states at several points in the tape that he never saw anyone, and it's only when the questions become more pointed that he just decides to give answers, whether or not they're truthful.
He said he saw a black man, no hair, no glasses.
Right, so he later
Is
states,
that what Mr. Andrade indeed looks like?
my understanding is that he is a black man, but I
Does he have hair?
don't know if he did at the time or if he does to
Is there any, I gather that was, of course, the first statement made by the defendant, that it was Mr. Andrade who appeared to have
Correct,
done
that's what he
it,
told the police during his first interview.
friend had an alibi. Is there any evidence in the record as to why the Commonwealth credited the alibi? Is there anything there?
I mean, there's nothing really in the record beyond the fact that she testified that D-Lock was at home with me and several other members of her family. And it's, again, that's for the jury to weigh the credibility. Do they believe this girlfriend or not?
So Andrade's girlfriend testified at trial.
Andre's girlfriend did, yes. I believe it's in volume 4.
What did she offer?
Well, I don't know specifically if the Commonwealth was aware that the defendant was going to take the stand in his own defense and go completely with a new narrative.
So that was in case he used his
Right, so the
old
Commonwealth
narrative.
wanted to just make clear that D-Lock had nothing to do with this case, and his alibi was, if you credit the witness.
The trial judge found the child was not really competent to testify, is that
Right,
right?
he noted in his findings that the child kind of went back and forth. He started out by saying, I didn't see anyone, I didn't hear anyone. When I went to bed, the TV was there. When I woke up, it wasn't. And he kind of makes this inference based on the TV being missing that someone was there and that someone probably also killed his mother. So it's come...
But going to that point, I thought the judge said, if I were to take this further, I would need to have an evidentiary hearing and determine the competency of the child.
Sure.
But I don't need to do that because I find that even if he were competent, it wouldn't matter.
Of course, yes.
So the judge didn't rely upon a finding of incompetency in reaching
Right.
his ruling.
Right, absolutely. So he never reaches a conclusion as to the competency of the child. He recognized that some time has passed. In the videotape, the child's 4. At the time of trial, I believe he would have been 7 and even older now. So it's tough to determine the 4-year-old's competency at the time when he's 7 years old. And indeed, he recognizes that an evidentiary hearing would be warranted on that question, but because the defendant failed to show how the evidence would have been a real factor to the jury, such evidentiary hearing on that issue wasn't warranted. It's the Commonwealth's position that the child's statements, inasmuch as they are exculpatory, are only exculpatory with respect to who took the television. The child's, when he does answer affirmatively to seeing someone later to the leaded point in questions, he says that he saw him took the TV. That doesn't necessarily mean that that same person he saw took the TV drove the knife into his mother's neck. So this evidence does not cast doubt on the justice of the convictions because it does not eliminate the defendant as the killer. With respect to the due process argument and whether the defendant's testimony would be admissible at a future date, the Harrison and Charos exception is not applicable here. First, the exception only applies to a defendant's former testimony where it was prompted by and offered in response to improperly admitted evidence. We don't have improperly admitted evidence. Even if the evidence was withheld by some mistake by the Commonwealth, this exception still would not apply. The defendant is arguing that if he knew about this tape, he would have either gone with the first story that wasn't working and never would have testified about Garcia being the killer. So which one is the truth? Is it the Garcia story, the DeLocke story? In the defendant's affidavit for his motion for a new trial, he seems to stick to the trial testimony he gives in as much as he admits to being at the home and telling the children to go to bed while his mother's being murdered so they don't see anything. He makes that statement in his affidavit. So allowing him not to have that testimony in at a future hearing would just be a misapplication of this exception.
But you agree that, I guess you would say the Commonwealth did hand it over, but you agree that the Commonwealth had an obligation to turn this over?
Absolutely.
Okay, so it's not an issue of whether it was appropriate to not turn over.
Absolutely, yes. And it's the Commonwealth's position that we did hand it over. Yes, best practices would have been to have a record that we did so. Yes, it's not in the certificate of compliance. I don't allege that it was there. And in the future, hopefully it would have been included. However, it just, as Judge Nickerson found, it simply wouldn't have made a difference. It would have been weak tea, as he calls it. And whether or not the defendant knew that this tape even existed, his affidavit and his counsel's affidavit make clear that he was aware of the children. He was aware that they were in the home, but not in the room where the murder took place. They contemplated calling the children as witnesses, and they agreed it was best trial strategy not to, because the defendant, even if he's there not as the murderer but as a witness, he knows that those children didn't observe anything relevant to his defense, and he makes the informed decision not to call these children in support of that. If there are no other questions on this point, the Commonwealth would rest on its brief with respect to the 33 issues.
Okay, thank you.
Thank you.